Members of the jury, as counsel have stated, the charge of the court is oral. You will have nothing to take with you to the jury room except the form of verdict. In this case, the plaintiff contends that the defendant was negligent in several respects and that negligence was what is known as a proximate cause of the collision and of his injuries, and that he suffered certain injuries and suffered pain and will suffer pain and incurred medical expense and will, in all reasonable probability, incur medical expenses in the future, and that it has now impaired his ability to earn a living about his earning capacity. The defendant denies these allegations and says that in any event, if the collision occurred as the plaintiff contends it did, that the plaintiff himself was guilty of contributory negligence in certain respects, and that his contributory negligence was a proximate cause of the collision, and of any injury or pain or suffering that he has had or will have. They further contend that he is not injured to the extent that he says he is, suffering to the extent he says he is, and will not suffer to the extent he claims he will as a result of this collision. Now, negligence, gentlemen, means a failure to exercise ordinary care. You see, each party is claiming the other negligent. Ordinary care means the degree of care which an ordinary person would exercise under the same or similar circumstances. Another definition of negligence is the doing of that which an ordinarily prudent person would not do under the same or similar circumstances, or the failure to do that which an ordinary prudent person would do under the same or similar circumstances. I will illustrate that by summing up before the conventions of both the plaintiff and the defendant as to the alleged negligence of the other. The plaintiff contends that the defendant's driver was negligent in cutting across the highway suddenly and in front of him, and of failing to keep a proper lookout, and in failing to yield the right-of-way to him. Perhaps, in other words, the speed at which he was traveling under the circumstances. So you see, the plaintiff charges the defendant was doing something affirmatively, which they say an ordinary prudent person would have done under the same or similar circumstances. Either is negligent, gentlemen, the doing of that which an ordinarily prudent person would not do under the same or similar circumstances, or the failure to do that which an ordinarily prudent person would be under the same or similar circumstances. Now, the plaintiff says that these are acts which constitute negligence, or these omissions constituted negligence, and the defendant says that the plaintiff himself was guilty of contributory negligence, which means an act of negligence, an act of omission of negligence on the part of the plaintiff, which concurring with or coinciding with the nature of the defendant became a producing cause of the collision, and without which it would not have occurred. Now, each of them say that the negligence of the other was a proximate cause of the collision. The defendant says that the plaintiff himself was guilty of contributory negligence in failing to keep a proper lookout for other vehicles on the highway, in driving at a dangerous and excessive rate of speed under all the circumstances at the time, and in driving at a rate of speed in excess of 45 miles per hour, and in failing to turn his car to the left in order to avoid the collision, and in failing to apply his brakes in time to avoid the collision, and in failing to slow down his car so as to avoid the collision. Now, each of them, as I say, contends that the negligence of the other was a proximate cause of the collision. There can be more than one proximate cause. In other words, one person can be guilty of negligence, and it can be a proximate cause of the collision, and there may not be any other. But the other person can be guilty of negligence, and it is a proximate cause of the collision, and both of them can be a proximate cause of the collision.
think I got that one pretty well.
That was,